Kind attention, please. I request all the audience to ensure that your mobile phone is in silent or switch off mode. Throughout the final session and the valedictory session, you are asked to maintain silence. And we request you to quickly finish off your lunch once the lunch break is announced. So we'll let you know when to do that. Kindly ensure that you remain silent throughout the session. Contempt of court.
council solicits to begin. Much obliged. Mic check. May it please this honorable court. The council acknowledges the gracious presence of your ladyship. However, for the convenience of the arguments, the council seeks permission to collectively address the bench as your lordships. Much obliged, your lordships. Your lordships, this is council 1 from the side of the petitioners and will be addressing the issue 1 and 2, and my co-counsel will be addressing the issue 3. Your lordships, the council would like to state the jurisdiction of the instant case. Your lordship, the council for the petitioners have approached before the Honorable Supreme Court of India under Article 32, your lordships. Would your lordships appreciate a brief perusal of the facts of the case in hand? Good. Much obliged, your lordships. Before submitting the issues, your lordships, the council would seek permission to submit the compendium of the cases cited, your lordships. Much obliged, your lordships. Your lordships, the very first issue that I'll be addressing is whether the instant petition is maintainable. Your lordships, the council seeks to answer in affirmative, your lordships. Your lordships, for a petition to be admissible before the Honorable Supreme Court of India, under Article 32, the petitioners must have their fundamental rights violated, which was very true in the instant case, your lordships. Your lordships, through the amendments made to the Advocates Act and the changes brought into the Bar Council of India's rules, the Union of India has violated the Article 14, Article 19 and Article 21, which forms a golden triangle under the basic structure doctrine, your lordships. And how the rights have been violated will be dealt in the subsequent issues, your lordships. Further, your lordships, drawing your attention to page 2, much obliged, your lordships. I'm the petitioner for the, I'm the counsel for the petitioners.
Company or what?
Your lordships, I'm the state bar councils of 3 states and advocacy organization for the advocacy body, your lordships.
You are a society or a company or what? Who are you? Or association?
A human rights advocacy body, your lordships. It's a Indian Council for Legal Service.
Whether such society is a legal person in law.
Indeed, your lordships. Under Article 12, a company is also
You say you are a society. You are association.
It is an association, your lordships.
Association is a society.
Association is considered as a person, your lordships.
No.
Apologies, your lordships.
Society is not, society or association is not a juristic person at all. Only a company is a society.
Your lordships, since Indian Council for Legal Service is standing on behalf of all the advocates, it has the locus standi before the Honorable Supreme Court.
Merely the presence of advocates will give you a right to give you the locus standi to file this petition?
It is a human rights advocacy body, your lordships. It's more or less like an NGO, your lordships.
Okay. So NGO, collectively that association is having a fundamental right.
Indeed, your lordships.
Yes.
Much obliged, your lordships. Moving further, drawing your attention to page 2, para 1 of the Moot proposition. Page 2, para 1 of the Moot proposition. In the second line, your lordships, it stated that in August 2015, Mehta BCS chairman announced that 30% of lawyers were fake. Although the exact numbers could not be exactly ascertained by now, and that the BCS would have final figures within 7 months. Your lordship, since then there have been no update on this, but then the amendments made are based on such vague grounds, your lordships. Moving further, your lordship, the counsel for the petitioners have invoked the original jurisdiction of this Honorable Supreme Court under Article 32 as upheld in the case of Chiranjit Lal Chowdhury versus Union of India, where it was stated that the original jurisdiction of the Supreme Court can be invoked in any case of the violation of the fundamental right guaranteed under the Part 3 of the Constitution, your lordships. If your lordships are convinced with the issue 1, I'll proceed with the issue 2, your lordships.
Saying you are not a juristic person at all.
But I'm standing on behalf of all the state bar councils as well, your lordships.
Sir, if that is the case, under which provision of law you should have appeared before this court?
Your lordships, advocacy body does
If you are representing all the states, then under which provision of law you should have approached?
under Article 32 in itself, your lordships, because the amendments made here are by
Even
the...
for the states, you will be coming under Article 32.
Indeed not, your lordships. Sorry, your lordship, could you pardon, please?
No, you said first, initially you appeared for the association, and because of that you are before this court under Article 32.
Indeed, your
But
lordships.
you are representing the states, means under which provision of law you will be appearing before
If
this
I was only representing the states, it should have been under 131, your lordships, but here it's for the enforcement of fundamental rights, your lordships. It's not for the dispute arising between the center and the state, your lordships. Hence, we have approached before under Article 32, your lordships.
States also should come under Article 32.
Indeed, your lordships.
If the fundamental rights of the states is violated,
The states have come on behalf of the legal advocates, your lordships.
then in which jurisdiction you will invoke the jurisdiction? Under which jurisdiction you will invoke?
Since it's for the enforcement of the fundamental rights as stated by the fact sheet, your lordships, it is under Article 32, your lordships.
The question is very simple. They want to know whether you can invoke the jurisdiction of this court away from Article 32 or 131.
Article 32, your lordships. Much obliged, your lordships. Proceeding with the issue 2. The issue 2 that I will be addressing is whether the amendment and rule pertaining to uniform standards in legal education by the Bar Council of India is arbitrary to the constitutional principles and guaranteed rights of citizens and non-citizens. Your lordship, the council humbly seeks to answer to this as well in affirmative. Your lordships, the amendment made to the part 4 of the BCS rules, that is the inclusion of rule 5 subclause A, confers the degrees on the basis of citizenships, your lordships, permitting the enrollment of Indian citizens and prohibiting the access of legal education to foreign nationals, your lordships. Your lordships, drawing your attention to page 17, para 21 of the memorandum of the petitioners, your lordships. Page 17, para 21 of the memorandum, your lordships. In the case of Mohini Jain versus the state of Karnataka, the Supreme Court held that right to education is the essence of right to life and directly flow and interlinked with it. And life, living with dignity, can only be assured when there is a significant role of education, your lordships. In the case of Mohini Jain versus state of Karnataka. Further, your lordships, drawing your attention to green flag 4 of compendium. Green.
Whether Unikrishnan case and Mohini Jain's case are relevant to which sort of an education? Higher education?
Higher education, your lordships.
Are you sure?
Indeed, your lordships.
So right to education, then if that is the case, then why that the constitution amendment has not incorporated higher education as well?
Your lordships, right to education under Article 21A states that there must be compulsory and elementary education to the age group of 16 to 17 years, 16 to 14 years. But this right to education is under Article 21, even though it's not
So
deliberative.
what is the facts? Mohini Jain's facts and Unikrishnan's facts, are you aware of it? Is it relevant to your case right now in hand?
But the judgment is relevant, your
See,
lordships.
you cannot mechanically take only the judgment part.
Indeed, your lordships.
Whether the facts and the circumstances are the same.
The council, please ignorance, your lordship. The council is not aware
But
of
the
the same.
council is taking that as a precedent and you have placed it before.
Indeed, your lordships. In many other cadena of cases, the Supreme Court has held that the right to education is a facet of the right to life under Article 21, your
We don't deny
lordships.
on it. We don't deny on
You
it.
need to have
Indeed, your lordships.
You need to have a logical reasoning for quoting a case.
Indeed, your lordships. As I already stated, the cadena of cases of the Supreme Court has held that right to education is a facet of right to life, your lordships, under Article 21. Moving further, drawing your attention to flag 4 of the compendium.
So if at all, if I don't receive my legal education, my fundamental right gets violated.
Indeed,
and my
your-
right to life is getting violated.
Indeed, your lordships. I'll prove that in the coming case, your lordships. In the case of Louis de Rey versus Union of India, it was observed by the Honorable Supreme Court that the right established under Article 21 applies to both citizens and non-citizens, your lordships. Hence, right to education being the very facet of the right to life, violating the right to education is in accordance to violating the right to life, your lordships. Hence, this amendment made to the rule 5 stands arbitrary, your lordships. Indeed, your lordships. The State Bar Council is representing all these, your lordships. Your lordships, the State Bar Council is coming under, before the court under Article 32 for the enforcement of fundamental rights of the citizens and non-citizens, your lordship, because in the case Indeed, Your Lordships. Your Lordships, in the case of National Human Rights Commission versus Your Lordships, fundamental Article 41 is not only limited to the citizens of India, Your Lordships, but also to the citizens of foreign nationals, Your Lordships, and hence we have the locus standi before this.
See, fundamental rights.
Indeed, Your Lordships.
There are two categories.
Indeed, Your Lordships.
One is for citizens, certain things are for citizens,
Indeed.
certain things for non-citizens. Whether this fundamental right to profession is available to a non-citizen.
In the amendments made, it's been curtailed.
19(1)(g) of the Constitution, 19(1)(g).
Indeed, Your Lordships. In 19, indeed, Your Lordships.
Now, then how can you claim for non-citizens also as a fundamental right, violation of fundamental
Your Lordships.
See, the Constitution itself has been framed to protect the rights of Indian citizens.
Indeed, Your Lordships.
So they cannot claim it as a matter of right.
Indeed, Your Lordships.
So you cannot correlate Article 14 with the citizen as well as a person who is not a citizen. So how do you say it is arbitrary? And when there is a reasonable restriction, it is also constitutional in view of Article 19(6).
Indeed, Your Lordships, but as I already stated, in the case of National Human Rights Commission versus the state of Arunachal Pradesh, the Supreme Court held that the right to equality extends not only to the citizens of India, but also to the citizens of foreign nationals, Your Lordships. Indeed, Your Lordships, coming to that, since the distinction made between the citizens and non-citizens is in violation of the Article 14, Your Lordships, it upholds their rights before the Supreme Court, Your Lordships.
Article 14, I agree.
Indeed, Your Lordships.
Article 19(1)(g) applies for only for Indian citizens. Non-citizens cannot claim right under Article 1(g).
Your Lordships, the contention here is about the legal education and not about the profession.
Legal education as well as the profession.
Your Lordship,
Kindly read the Article 1(g).
to practice any profession or to carry on any occupation, trade or business, Your Lordships. The very issue will be dealt with by my co-counsel in the third issue, Your Lordships. I'll be dealing with only with the education perspective, Your Lordships. Indeed, Your Lordships.
Enjoy the right. When such right has been infringed upon by an action by, the public authority,
Indeed.
can come before this court.
Indeed, Your
Now,
Lordships.
when non-citizens are not given the right, either as a fundamental or constitutional right, how that you are saying you are representing for that?
Your Lordships, it's not just in the just in the representation of foreign nationals here. A lot other factors are taken into consideration, and this is just being one factor under it, Your Lordships. Much obliged, Your Lordships. In furtherance, Your Lordships, the amendment mates are not in accordance with the doctrine of proportionality, Your Lordships. Drawing your attention to flag 5, green flag 5 of the compendium, Your Lordships, in the case of Modern Dental College and Research Center versus State of Madhya Pradesh, the Apex Court laid down certain tests or the factors to test the proportionality of the amendments or the changes made, Your Lordships. And one of the tests being there must be a reasonable nexus, or the extent of interference must be proportionate to the need for such interference. Further, in the case of Anuradha Basin versus the Union. Indeed, Your Lordship, but it should have a reasonable nexus. The amendments made should be equal to the goal seek to achieve, Your Lordships. But in here, the restriction placed to the impure amendments by completely prohibiting, that is completely restricting, are not in any least restrictive measure, Your Lordships. Your Lordships, in the case of Anuradha Bhasin versus Union of India, referring to flag 6, Your Lordships, the Supreme Court held that only least restrictive measure must be applied by the state. But here there has been a complete ban on the...
Again, sorry for interrupting.
Indeed, Your
Are you
Lordships.
aware of the facts of that case?
Indeed, Your Lordships.
Okay. Can we know the facts?
Indeed, Your
In
Lordships.
what way it's related to this case?
Your Lordships, here there has been a complete ban on the legal education to the foreign nationals, Your Lordships. And in this Anuradha Basin versus Union of India, it was held that only least restrictive measure must be taken if there are any amendments to be made, Your Lordships.
Now there is a logic for your opponent to bring in such a regulation.
Indeed, Your
Isn't it?
Lordships.
So they have very many strong reasons where they said no, the large number of fake lawyers are there.
Indeed,
a
Your
consultative procedure has been there,
Indeed, Your
Isn't it?
Lordship.
So I think the running of the institutions in overall India, extending to around 1,800, the thing is the quality is not sustained. So obviously they have a strong reason to bring.
In August 2015, Mehta BCS chairman announced that 30% of lawyers were fake, although the exact number could not be exactly ascertained by now, and that BCS would have final
I
figures
agree.
within 7
Just
months.
The figures are not authenticated.
Indeed,
Do you
Your
deny the fact?
Lordships.
Do you deny the fact?
Indeed, Your Lordships. The fact,
So are you of the assumption that nobody is there who is there practicing as fake?
I'm not of the assumption, Your Lordships, I'm just denying the facts, Your Lordships.
No doubt. They lapse in bringing the exact figure. We agree to that.
Indeed, Your Lordships.
Now, there is an authentication when they say so many people are there without qualification representing before the court. Is it not affecting your interest?
Your Lordships, here it can be assumed that there might be more fake lawyers or no fake lawyers at all, Your Lordships. Standing with the no fake lawyers.
Any proof to say that there is no fake lawyers?
Indeed not, Your Lordships. There is no proof
You
either.
don't have a statistical data and they too don't have a statistical data. What's the point in arguing on that?
Presuming that there's no fake lawyers, Your Lordship, presuming the fact is in itself wrong, the fact provided by the fact sheet in itself is wrong, Your Lordships. The ground in itself are vague for the amendments.
Before which forum of law? You are before which forum?
Supreme Court, Your Lordships.
You are going to argue on the facts?
No, on the law, Your Lordships.
Then if you are going to argue on the law, then you should have some kind of a valid supporting document to say that this particular data is wrong, right?
Indeed, Your Lordships. Indeed, Your Lordships. May I please proceed with my issues,
Yes.
Your Lordships? Further, through the inclusion of subclause B, that is there has been a upper age limit posed on the evaluation of the legal education, Your Lordships, that is 20 and 25 years for 5 years and 3 years of graduation respectively. Your Lordships, in the case of Dr. Pradeep Jain versus Union of India, it was held that the right to education being a fundamental guaranteed right under Article 21, imposition of unreasonable age limit in admission to professional courses is in violation of Article 21, Your Lordships.
You are quoting a case wherein it is pertaining to enrollment.
It's talking about right
Now,
to
this
education, Your
this is
Lordships.
something with regard to admission.
Indeed, Your Lordships.
Now, how do you correlate?
It's talking about right to education being a fundamental right. Posing an unreasonable age restriction
The
is...
judgment wherein you quoted, no?
Indeed, Your Lordships.
The individual has completed the degree when he has gone for enrollment.
Indeed, Your
When,
Lordship.
I think when the other side has put a rider
Indeed, Your
beyond
Lordships.
45 years, he could not enroll.
Indeed.
Then therein the issue was there. But yours is something different.
Indeed not, Your Lordships. In this case, it was very much held that the right to education being the fundamental right, posing an unreasonable age restriction is arbitrary, Your Lordships.
For example, Article 21A puts a restriction on the age.
Indeed, Your Lordships.
So fundamental right of education is only to the primary education, not to the higher education
Indeed not, Your
or
Lordship.
professional courses.
Professional courses, Your Lordship. Legal education being one of the professional courses, posing an unreasonable age restriction on this is violative of constitutional rights, Your Lordships, under Article 21.
No, it's a reasonable restriction. It is not ultra vires Article 19(6).
Indeed not, Your Lordships. Right to education is
No,
does
see,
not
the
have a...
restriction is not ultra vires 19(6), because under 19(6) the state has got powers to impose restrictions for professional and technical qualifications.
Indeed, Your Lordships, but either the counsel for the petitioner still strongly contends that there are many more other groups of individuals who might be interested in the persuasion of the legal education, Your Lordships, and
No, you
posing
have
such...
to substantiate how is it ultra vires the constitution. So if unless and until it is ultra vires the constitution, then you cannot dub it as an arbitrary amendment.
Indeed, Your Lordships. India being one of the developing countries, Your Lordships, there's a big amount of population who is still below the poverty line, and they may not have been able to pursue this education within this age period, Your
So
Lordships.
it is naturally necessary to protect the citizens of India. Why do you bother about the non-residents or...
Indeed not, Your Lordships. The age restriction posed is on the citizens of India, Your Lordships, and I'm contending on the same, Your Lordships.
Yes, please.
Much obliged, Your Lordships. Further, Your Lordships, drawing your...
Ms. Counsel, will you be able to enlighten us on Pradeep Jain's case?
Indeed, Your Lordships.
What is the logic and what is the nexus between this case and the Pradeep Jain's case?
instant case and the Pradeep case.
Pradeep Jain case,
In
what's the nexus?
Your Lordships, in the instant case,
What's the facts about Pradeep Jain's case? What's the facts all about Pradeep Jain's
the
case?
council pleads ignorance, Your Lordship. The council is not
See,
aware
Miss
of the
Council, you
facts.
have come up with all the judgments and you seek for every fact's ignorance. I don't understand. The court has to go with facts and circumstances of the case, right? When it is deciding on the precedents also, applying the precedents also.
Indeed, Your Lordships, but the facts for this, the council pleads ignorance, Your Lordships. Much obliged, Your Lordships. Your Lordships, drawing your attention to Section 7H of the Bar Council rules, it requires the Bar Council to promote legal education and to lay down standards of such education in consultation with the universities in India imparting such education and the state bar councils, Your Lordships. But in the very instant case, the Bar Council of India, while making the changes to the rules, has failed to consult the universities in India and the state bar councils, Your Lordships.
1 minute. Are you representing the university also now?
Indeed not, Your Lordships.
Okay, in that case, university would have come before this court.
Indeed, Your
When
Lordships.
they have not volunteered to be there before us.
Indeed, Your
What bothers
Lordships.
you?
But the state bar councils are contending that it has not even...
No doubt, we agree to the point.
Indeed, Your Lordships.
Before passing a rule, they need to consult the universities.
Indeed, Your
Isn't
Lordships.
it? They must be the agreed party.
Indeed, Your
Isn't it?
Lordships.
When they are not agitated,
Indeed, Your
what's the
Lordships.
locus for you?
Your Lordships, I was just reading the Section 7, Your Lordships. We are standing still on behalf of the state bar councils, Your Lordships. Much obliged, Your Lordships. Hence, Your Lordships, the Council for Petitioners contends that the amendments made in the instant case are ultra vires to constitutional principles and not within the framework of the Bar Council rules as well, Your
See,
Lordships.
one more question. 7H is only regarding the curriculum or the education pattern. So they did not consult for the proposed amendment with the universities.
But Your Lordship, under Section 7H, it states that it must
7H
be...
it says to promote legal education and to lay standards of such education in consultation with the universities. This proposed amendment
Indeed, Your Lordships.
only prescribes the age limit for which they did not consult. Supposing there is going to be a change in curriculum.
Your Lordship, the fact sheet states that the age bar has been imposed for the promotion of the legal education, Your Lordships, for the legal
Promotion
reforms.
of legal education is one thing.
Indeed, Your
Curriculum
Lordships.
is one thing.
Indeed, Your Lordship.
Supposing they want to frame a curriculum, naturally they will have to go before the, they have to have a consultation with the universities.
Indeed, Your Lordships.
But the proposed amendments only puts up a restriction.
Indeed not, Your Lordships. The amendments are laid to bring in the uniform standards, and in the Section 7H it's stated that to lay down standards of such education, it has to be in consultation with the universities and the state bar councils, Your Lordships. Much obliged, Your Lordships. The council for the petitioners rests the issues with 1 and 2, and my co-counsel will be taking over, Your Lordships. It was an honor pleading before Your Lordships.
The council seeks permission to approach the dais. Much obliged.
Warm greetings to the bench. This is Counsel 2 appearing behalf of the petitioners. May it please this court. The counsel would be addressing issue 3, which is particularly based on the uniform standards, where the amendment was made by the Bar Council of India, which is violative of the constitutional principles guaranteed under the Part 3 of the Constitution. Your Lordships, any amendment which is made by the government body or any institution should not restrict or violate the fundamental rights. In the instant case, Your Lordships, the amendments which are made by the Bar Council of India are directly infringing all the fundamental rights of the advocates. As Your Lordships, right to livelihood, which is guaranteed under the Article 21 of the Indian Constitution, which is considered in the catena of the Supreme Court decisions, it is addressed that the right to livelihood is the important facet of the right to life. Your Lordship, right to livelihood is a basic right which gives life for the other fundamental rights, as it gives a means for the livelihood. Your Lordships, in the instant case, the amendments which are made under the Rule 10, 1 clause subclause A, the state restricts the state by limiting the period of enrollment for mere 3 years after the graduation, has stripped away the right to livelihood of the advocates, Your Lordships. Further, Your Lordships, the council humbly submits before the bench that right to equality, which is guaranteed under the Article 14 of the Constitution, is also violated, as the second amendment which is made under the Rule 10, 1 subclause A, which states which states that the amendments should be in effect with regard to the batch 2023 to 2024. Your Lordships, the clear discrimination, this is a clear discrimination between the advocates who are appearing in the previous years and the advocates in the thereafter years, Your Lordships. Further, Your Lordships, the Council contends that in the instant case, the restriction in the Rule 10(1) subclause A of the Part 6 limits the eligibility itself to appear before the ASB exam within the 3 years of law graduation. 1A, Your Lordships. Indeed, Your Lordships. It is in the page 4, which states, any law graduate within 3 years of completion of the course, that is, receiving the degree, shall be eligible to appear in the ASB exam. Your Lordships, interpreting the very amendment by the Bar Council of Scindia, the Bar Council of Scindia is putting a ceiling limit in the enrollment, where an advocate who has completed the course shall only enroll within the 3 years of the completion of the course. Your Lordships, the Council contends that what about the rights where many advocates has completed the course of the law, but they are exceeding more than 3 years of 3 years. They are not eligible to appear for the ASB
Why not
exam.
be considered this way? Non-serious person being taken away from the enrollment purview.
Your Lordship, only because an advocate is not appeared for the ASB exam, he cannot be considered as a non-serious person, Your
So
Lordship.
kindly remember, all
Indeed,
people
much
who have
obliged.
taken the law degree need not go for practice. They have their own option. It's only optional. In which case, when somebody is not really interested to come to the bar, when they're given a reasonable timing of 3 years, so naturally they must be ousted from the list.
Your Lordship, the Council respectfully disagrees for the arguments, Your Lordships, as the fundamental rights of the citizens, which are guaranteed in the Constitution, are the supreme
Are you
law
of
of the
the
land.
view all students who have taken the degree ought to be enrolled for taking a practice?
Indeed, yes, Your Lordship, all these have the rights for the enrollment to practice the law. Then the right to livelihood, only with the mere contention that only within the 3 years restricting the year for the enrollment cannot violate the fundamental rights of the whole.
One way it is helpful for them to choose their profession.
In Your Lordships,
Because they can decide at the early stage, right, whether they want to pursue the profession or they want to go for any other profession.
indeed, no, Your Lordships, only considering one aspect, the other aspect of the group cannot, the other aspect of the
So
groups
assume,
having the.
Ms. Counsel, if at all tomorrow they say even after 3 years or after 10th year of your any other profession which you are choosing, they can enroll if they say, then it's fine for you. Then
Indeed.
this provision is fine for you then.
Indeed, yes, Your Lordship. Law is a noble profession which do not need an age bar, Your Lordships. Neither these ceiling limit for the enrollment stands to be valid, Your Lordships. The Constitution itself says that the preamble itself grants
So
that.
now my question is, if
Indeed,
at all
Lordship.
if they say even after 3 years they can enroll, they can write ASB examination. If they say so, then it's fine for you.
Indeed, yes, Your
Then
Lordships.
you're agreeing with the ASB examination.
Indeed, Your Lordships.
So that is the
Exam-
one and only restrictions for you. Otherwise, you're ready to appear for ASB examination.
Indeed, Your Lordship. The Council strongly contends that ASB exam is permissible, but the restriction which is barred, where the advocates have to enroll only within the 3 years, is violative of the Article 14, Your Lordships.
Are you aware of the fact that even for pursuing a degree, there is a minimal year which has been prescribed within which the candidate need to complete the course?
Indeed, Your Lordships.
Are you aware of it?
Your Lordships, that is regarding the
Whether it's-
education.
Whether it's a 3-year degree or 5-year degree, there
Indeed,
is a
Your
time
Lordships.
stipulation within which they need to complete the course.
Indeed,
If
Your
they are not
Lordships.
completing it, naturally they need to forego the study.
Indeed, Your Lordships, about the bar, about the age bar, my co-counsel have already dealt before the Honorable Bench, Your Lordship.
No,
The
it's
very
not-
exist.
It's not connected with age.
Completing the course.
Completing
It's
the
not
course.
With regards to admission.
Indeed, Your
We have
Lordships.
10 plus 2. For example, if I join for a 3 years course, I have to complete it within 2 years. 3 years
Indeed, Your
plus 2
Lordships.
years will be the given grace time.
Indeed, Your
Similarly, 5 years plus 2 years. So
Indeed,
I
Your
have to complete
Lordships.
within a particular age limit only.
Much
So what is
obliged.
wrong in having a particular stipulated time to choose your profession?
Indeed, Your Lordships, only 3 years clearly violates the right of the livelihood of many advocates, Your Lordships. This is so unreasonable.
Are we not observing a logic here? Any candidate who is not studious for taking up the legal education within the stipulated timing, he has been thrown out.
Indeed,
He is
Your Lordships.
foregoing all the spent time which has spent for pursuing the course. In similar way, within 3 years, if any candidate was completed law, if he's not serious enough to take the practice, let him take up other occupation. What's the logic for him not to bring in before the court and then see to that he is stumbling the clients who are before him?
Indeed, no, your lordships. Just because a student is not studious, his fundamental rights cannot be curtailed. Just the mere ground that the advocacy needs only the quality advocacy skills, your lordships. Even those students who are not students shall be given a right for enrollment.
Counsel, few minutes before you said advocate profession is a noble profession.
Indeed, your lordships.
So then do you want quality advocacy or not?
Indeed, your lordships, quality advocacy is permissible, your lordships. But on the other hand, your lordships, only for emphasizing on the quality advocacy, the quantity or the number of advocates appearing before the bench before
and
the
appearing
BCS.
for the people. You are appearing for, as a public investigation, appearing for the mass advocates.
Indeed,
but you
your
are
lordships.
saying that quality can be compromised. And because of that,
Indeed.
you will also compromise tomorrow with the justice mechanism also.
Indeed, no, your lordships. There is no compromise with the quality nor the quantity, your lordship. The council strictly
Talking about the quantity, I am talking about the administration of justice, quality administration of justice.
Indeed, your lordships, much obliged. The council again strongly contends, your lordships. There is a difference. These discrimination which is restricting within the 4 years is directly infringing the fundamental rights of the advocates who can appear for the
So do
ASP
you know, for
exam.
many competitive examinations, we
Indeed,
have certain
your
age restrictions.
Indeed, your lordships.
Yes, for example, if you take Union Public Service Commissions, we have attempts, like few only restricted attempts we have.
Indeed, your
Why
lordships.
then that is also arbitrary, right? Anyone can join the service at any time, any point of time, right?
Indeed, no, your lordships. Taking that as ignoring the persuasive factor, the council again strongly contends that mere restriction only to the 3 years clearly violates the fundamental rights of the that
How?
group.
You don't want to clearly violate, I mean, you cannot ignore merely. You can have to say with substantive points. You should have some logic behind your arguments.
Indeed, your lordships. Your lordship, if I may go with the content, with the matters by the bench, your lordship, what about the rights of those advocates who did not appear for the ASB exam within the 3 years? They might be pursuing. Your lordship, we cannot contend that they were not studious, neither they were of no interest in the practice. What if those advocates or those people who wanted to appear for the enrollment were doing something else for the country? They can be the MBBS students or anything. Your lordship, the students who are already well versed with others double
Ready
degrees.
to do something for the country by choosing any other profession. Why do they again want to come to pursue, I mean, why do they want to enroll as an advocate?
Your lordships, it is being a citizen, it is the right of every citizen that he or she can pursue anything, and those rights cannot be curtailed merely on the basis of the restrictions. Much obliged. Yeah.
Arbitrary and you challenge it. Okay.
Much
For
obliged.
Any profession, supposing a person who has shifted his profession to some other
Indeed, your
faculty,
lordships.
and after some time at the age of 40 or 50 is coming in English, can you say that it is good
Indeed, your lordships.
for the betterment of the community and legal fraternity?
Your lordships.
No, wait. Is it not the duty of the Bar Council of India to uphold the majesty of the system, dignity of the system, to have a quality, education and the professionals? Supposing a person has not enrolled and he has shifted to some other profession, and after 10 years he incurred loss and he wanted to shift it again to come back to legal profession, will it be allowed? Can you entertain it?
Much
Does it not
obliged, your
affect the other
lordships.
youngsters?
Much obliged, your lordships. As the bench has rightly mentioned that there cannot be a restriction, as you told that after few years even he can appear for them. Indeed, your lordship, the council is also trying to prove the same. Why not after educating in the other profession, why not a person can still be enrolled, removing the bar of 3 years, your lordships? Lordship, the council is contending that as the bench has rightly mentioned, that the bar on the age, that is according to the rule 10(1) subclause A, where only within bar on the year, only in the 3 years one can appear for the enrollment. The council contends that the bench has rightly mentioned that even if a person is pursuing any other degree, even after 50 or the 40 years, yet he has to be given a right for enrollment, your lordships. Indeed, your lordships, considering the same. Indeed.
going to talk, argue on that. There's no point. Then we cannot regulate legal education at all or legal profession at all.
But indeed, your lordships, but in this particular case, as the facts reveals that there were growing population in the advocates, and if these advocates are not given a chance for enrollment itself, then what about the legal professing the for the legacy of the legal profession in the country, your lordships? The council.
Bar council has fixed up a time limit for enrollment.
Indeed, your lordships.
You
When
understand?
much
It has not been restricted or barred completely. Only 3 years of time, 5 years of time, reasonable. Time limit has been framed for enrollment.
Much obliged, your lordship. This restriction is unreasonable, your lordships, as bar on the three.
Unreasonable. That is one question.
Indeed.
Second question is that there is a difference between the term bar and restriction.
Indeed, your lordships.
So that is what is the question, because we are not barring you from getting enrolled. We are
Indeed.
restricting you to get enrolled. That's
Okay.
it.
Reframing my
One more
contention.
thing, the norms are going to be implemented only prospectively,
Indeed, your lordships.
isn't it? So it's not in vague as of now.
Indeed.
How you are agreed now? How that you are now seeking to protect the interest of somebody who will be completing the course after 3 years or 5 years?
Your lordship's constitution is supreme legislation of the land, and it is
You have come
embodied.
before this court invoking Article 32.
Indeed, your lordships.
So only when you enjoy a right,
Indeed, your
when
lordships.
when this right is infringed upon, you can come before this court under Article 32.
Indeed, your
Now
lordships.
there is no right at all.
Your lordships, the council set forth these
Yes, sir.
contentions which states that there is an infringement of the constitutional principles, your lordships. Firstly, that Article 21, which is substantiated by the previous contentions, that right to livelihood, which is the important facet of the.
So even you started your argument with that, because
Indeed, your
livelihood is a very important principle that is all there.
Indeed.
But we are not saying you cannot practice in India at all, or you cannot enroll in India at all. We are not saying. We are saying you have to enroll yourself within 3 years. What's wrong in it?
Your lordship, this restriction is on the ground of unreasonable.
On what basis? That
Your
is what is the question. So that is what logical answer I need, or a legal answer. Not again beating around the bush with the factual reasons.
Much obliged, your lordships. The constitution gives every citizen the right to practice according to 19(1) clause G. Your lordships, when the Bar Council of Scindia.
Same 91G has reasonable restrictions.
Indeed, your lordships. And the reasonable restriction is in the Article 19 clause 6. The restriction is in the interest of general public. Your lordships, in this case.
See, it is
This
not
is
only
not-
in the interest of general public.
Indeed,
See,
lordships.
they can impose restrictions for professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business. So they can bring up any curb or restriction imposing certain conditions that you should follow the norms.
How do you assign the order as modified?
Indeed, your lordships. With reference to the doctrine of proportionality, your lordships, the very aim of the Bar Council of Scindia is to give improve the legacy of the law, your lordships, legal profession. But in the instant case, because of making these invalid amendments, your lordships, there is
The
no
amendments-
legal nexus.
The amendments are in consonance with the constitution. How do you say it is ultra virus the constitution?
Indeed, your lordships, that is the council for the petitioner strictly adheres that there is a violation of the fundamental rights,
I
and
want
hence
you to explain how it is ultra virus.
Sorry to intervene. Council, did you read Article 19 clause 6? Are you aware of 19 clause 6?
indeed, your lordships.
Could you please read 19 clause 6 subclause 1, proviso 1?
Indeed, your lordships.
You have to read 19 clause 6 last line, and then you have to start with this.
Indeed, your lordships. The professional or technical qualification
Before
necessary.
that, please read the prior line. 19 subsection 6.
Nothing in the subclause G of the said clause shall affect the operations of any existing law in so far as it imposes or prevent the state from making any law imposing in the interest of general public. Reasonable restriction on the exercise of the right conferred by the said subclause, and in particular, nothing in the said subclause shall affect the operation of any existing law in so far as it relates to or prevent the state from making any law relating to it.
Relating to what? Please read it.
Relating to the professional or technical qualification necessary for practicing any profession or carrying on any occupation, trade or business.
That's it. Your case is over, right? Your case rests.
Indeed, no, your lordship, the council respectfully disagrees
How?
as the reasonable restriction is general public interest. The council strongly contends that this restriction is unreasonable.
We do say that this is on the general public interest. They have got this restrictions because non-serious advocates, when they get enrolled, the clients are getting affected, the parties are aggrieved, there is no justice rendering mechanism is possible.
Much obliged, Your Worship. Merely for this reason, the rights of the fundamental rights of those advocates who have already...
Fundamental rights is not an absolute right for those advocates who are practicing this profession. There is a reasonable restriction in Art 96.
Indeed, Your Lordship. The Council strongly contends that this reasonable restriction itself is on the unreasonable grounds, Your Lordships.
So you are now challenging 196.
Indeed, Your Lordships.
There is no such prayer here.
The Council respectfully denies, Your Lordships. Much obliged.
Counsel, one question I would like to put you.
Much obliged.
You just leave alone all legal profession and the restrictions or all the legislations.
Indeed,
In
Your
general, as a legal person, as a common man, I am asking you. In all cases, any limitation, for filing a case, approaching the court, there must be a limitation. There is
Indeed,
a
Your
limitation
Lordships.
prescribed by law.
Indeed, Your Lordships.
Am I right?
Indeed.
Supposing if there is no limitation at all,
Indeed, Your
age
Lordships.
bar is not there, and can you say that 30 years of old man can be put into 12th standard, 10th standard? Supposing if there is no age bar, as you say.
Indeed, Your Lordships.
So, which it would lead to a very drastic condition, because in law, as you know well and aware of, there are restrictions for every little thing.
Indeed.
There must be a reasonable restriction.
Indeed, Your Lordships.
If you say that it is 3 years and 5 years are not reasonable, and what could be the reasonable restriction or limitation time?
Your Lordships, much obliged. Your Lordships, firstly, here there is no age bar. That is contended. Secondly, there is a bar in the years which an advocate is not allowed to be enrolled.
There is no age bar. That is what there is a restriction. That is what the court judge already asked you. What is the difference between restriction and bar? There is no bar,
Indeed,
but
Your
there is a restriction. Whether that restriction is unreasonable or not, that's the only point for consideration.
Indeed.
Taking into consideration of other aspects of law,
Indeed,
where
Your
there are limitations prescribed in every little thing.
Much
And
obliged.
supposing if there is no restrictions, and it will lead to a drastic situation, because there must be a reasonableness on part of any litigant to approach the court.
Indeed,
You
Your
agree with that
Lordships.
point or not?
Indeed, no, Your Lordships, the Council contends that the restriction itself is unreasonable. Your Lordship, instead of making this restriction only to the 3 years, the Bar Council of Sindhya would have removed this restriction, which is only limiting 3 years, Your Lordships. The Council here strongly contends and concludes that the Bar Council of Sindhya is arbitrary in the nature of... I bowed on Your Lordships. The Council did not mean to do so. Further, Your Lordships, moving on. In the present case, the Council strongly contends that there is a violation of the Article 14, that is the right to equality, Article 22, that is the right to livelihood, and Article 19, that is the test of reasonableness, 19, that is the right to profession, Your Lordships. And it's not the aspect under the Article 19, Your Lordships, it does not confer to the test of reasonableness, Your Lordships, as the Council contended there is the unreasonable grounds. Further, Your Lordships, the Council hereby contends that in the Maneka Gandhi versus Union of India, which is a landmark case which we all are aware, in which these golden principles, that is Article 19, 14, 21, were upheld as to be a basic structural doctrine. The act of the Council for the Respondents making the invalid amendments being arbitrary are restricting and are violative of...
We need to decide on validity or invalidity.
on the invalidity of the amendments which are made by the Constitution.
So whether is it valid or invalid will be decided by the court, because you are before this forum to decide on that, right?
Indeed, Your Lordships, much obliged. Much obliged. Your Lordships, hence the Council for the Petitioners contends that these articles which are forming a golden triangle are violative. Hence, the amendments which are made are against the doctrine of basic structure, Your Lordships. Further, the second distinct ground, which is whether the amendments in the rules are in contradiction to the provisions which are already existing in the Advocates Act 1961. Your Lordship, quickly drawing to the attention of the bench to page 4 of the proposition, which clearly states the amendment under the Rule 10, 1 clause subclause A, in the last page of the Moot proposition, Your Lordships, which firstly says, any law student pursuing pre-final year or final year law course shall be eligible to appear in the ASB. In the next very amendment, it states, State Bar Council shall enroll only law graduates bearing certificate of practice as prescribed above. Your Lordship, the Council contends the rule stated above is direct contradiction to the provisions in the Advocates Act 1961 as with reference to section 24 1 subclause C of the Advocates Act 1967 clearly states he who has obtained a law degree in law. Your Lordships, which means that in order to be enrolled in the respective State Bar Council, the completion of the law degree is must. Your Lordship, the Council contends that the Bar Council of Scindia should not override the already existing provisions in the Advocates Act 1961. As the bench is already aware that Advocates Act 1961 is a parent legislation, Your Lordships. On the other hand, the delegated legislation is the Bar Council of Scindia. Hence, Your Lordship, this is against, according to the doctrine of repugnancy, Your Lordships, when the provisions which are under the Parent Act are against the provisions which are made by the delegated legislation, the provisions under the Parent Act should prevail over the delegated legislation, Your Lordships. Indeed, Your Lordships.
The clause which you read now,
Yes.
which speaks something as to fixing the eligibility for taking the test.
Indeed, Your Lordships.
Simply because a candidate who is pursuing the course has completed the eligibility test.
Indeed, Your
It's
Lordships.
not to be enrolled.
Indeed, Your
You
Lordships.
need to complete the course, only then actually you will be taking the eligibility.
Indeed, Your Lordships. As you have rightly mentioned, Your Lordship, the contention is he has to complete the law degree. But Your Lordship, the amendment made in the Rule 10(1) subclause K also specifies on the pre-final law degree, Your Lordships. Hence, the Council is contending that there is a direct contradiction between the provisions.
How do you see the contradiction? Let me put it another way.
Indeed,
You might be knowing the general pattern now. While you are pursuing a PG degree, you are permitted to take the NET examination.
Indeed, Your Lordship.
Before completion of which, if you are clearing the NET, only on taking up the PG degree, you will be eligible for any position, whether it is JRF or lecturership.
Indeed.
The same logic applies here also, wherein instead of wasting the time after completion of the course, during the pursuance of the course itself, if the candidate is really competent, he is permitted to take up the examination. Now, what wrong in it?
Indeed, Your Lordship, the amendments which are made by the Bar Council of Scindia are only amended in the BCS, Your Lordship. No amendment is made under the Parent Act, that is the Advocates Act 1961. The Council strongly contends that there is a...
What sort of an amendment you are expecting in Advocates Act for this particular provision?
Your Lordship, there should not be any amendments, Your Lordship, as the Council contends that the very amendments which are made by the Council with the respondents all are invalid, Your Lordships.
No, I'm
Contradicts. Which provision of Advocates Act it contradicts?
The section 24, 1 clause, subclause C, Your Lordships. He who has obtained a law degree, Your Lordships.
Please read, the thing is, amended provision section 7, clause EA.
May I have it?
Amended provision inserted by section 7
Indeed, Your
in the
Lordships.
clause EA.
E subclause A, to regulate the ASBE and law standards of its regulations.
Lay standards.
Lay standards, my apologies.
Now, is it not within the purview of the Bar Council to do that?
Your Lordship,
In fact, they are facilitating the students who are pursuing the course.
Indeed, Your Lordships.
How that you are getting a grade of it?
Yet, Your Lordships, even if it is a favor or not,
Are you of the view permitting them to take the exam itself is injustice?
indeed, no, Your Lordships. The Council contends that the provisions, all the amendments which are made are in contrary to the Advocate Act itself, Your Lordships.
Where is the contradiction here?
Your Lordships, according to the section 24, 1 clause, subclause C.
Please understand. There are certain stages.
Indeed, Your Lordships.
First thing is that entry into the legal course.
Indeed, Your
Secondly,
Lordships.
completion of it.
Indeed, Your
Thirdly,
Lordships.
getting a certificate of practice.
Indeed, Your
For the
Lordships.
purpose of certificate of practice, you need to take up the examination.
Indeed, Your
Isn't it?
Lordships.
These are the norms.
Indeed,
Isn't
indeed.
it?
Much
So
obliged.
only after enrollment, after when he is empaneled, he'll be getting protected from the Bar Council in all the
Indeed.
parameters.
Indeed, Your
Now
Lordships.
towards facilitating a group of people, naturally the exam is permitted while they are pursuing the course.
Indeed, Your
How do you
Lordships.
see the contradiction here?
Your Lordship, the contradiction here is, firstly, the amendment is made which says that only a law student should. Secondly, again in the very amendment, it states that only pre-law final
It is
students.
facilitative.
Indeed, no, Your Lordship, it is just contradictory, and here, according to the doctrine of
Are you of the
repugnancy.
view the other party doesn't have the power to do that?
Indeed, yes, Your Lordships.
How do you substantiate it?
Your Lordships, even if the power is there, the power is used arbitrarily by the counsel of the respondents, Your Lordships, without these provisions are not in consonance to the Advocates Act, Your
See, you are
Lordships.
able to substantiate the arbitrariness in their action.
Your Lordships, as
Please continue, please continue.
much obliged, Your Lordships, as the priority of the council is to satisfy the bench, Your Lordships, the contradiction here is, Your Lordships, in the Advocates Act which specifies that the law graduation can only be enrolled. Secondly, Your Lordships, in the amendments which are made with the Bar Council of India, it says that even the pre-final year law students can be enrolled. Hence, the council strongly contends that these provisions are in the contradictory to the Parent Act, that is Advocates Act 1961, Your Lordships. Hereby, the council strongly contends that all the amendments which are made by the fellow councils are in the glare violation of the fundamental rights of the advocates and should be considered as inconsistent. Hereby, the counsel for the petitioner rests the arguments. The counsel seeks permission to move on to the prayer. Highly obliged, Your Lordships. Wherefore, in the lights of issues raised, arguments advanced and authorities cited, the counsel for petitioners humbly plead before this honorable court to kindly allow the writ petition before the Supreme Court. Secondly, to issue the writ of mandamus to the counsel for the respondents and to declare the amendments as unconstitutional, as there was a glare violation of the fundamental rights, or pass any order that may deem fit in the interest of equity, justice or good conscience. For this act of kindness, the petitioner shall duly bond forever pay. Indeed, Your Lordship. Indeed, Your Lordship.
While challenging their provision, which is ultra vires, you have filed a petition for mandamus.
Indeed, Your Lordships.
Very much clear there.
Indeed, Your Lordships.
What for mandamus is right?
Because, Your Lordship, the public authority or the...
Challenging a provision.
Indeed, Your
Saying
Lordship.
that it is an ultra vires to the constitution.
Indeed, Your
It's not
Lordships.
your duty to challenge that provision on the by way of the certiorari.
Indeed, no, Your Lordships. Indeed, no, Your Lordships. Much obliged. It was an honor to plead before Your Lordships.
It has to be certiorari.
Much obliged, Your Lordships. Much obliged.
Am I audible, my lord? The council seeks permission to address the bench of the Honorable Supreme Court collectively as your lordships and an alternate as your lords. Much obliged. My lords, this is council number 1 appearing on behalf of the respondents for the case concerning the Indian Council for Legal Service versus the Union of India and others. My lordship, council 1 would be dealing with the first and second issue, that is with respect to the maintainability of the instant petition and the uniform standard of legal education, and the second council will be dealing with the third issue, that is with respect to the uniform standard of enrollment in bar, my lordships. My lordship, before proceeding to the arguments, my lordship, the council would like to place preliminary objections to the points that was raised by the council for the petitioner, my lordships. My lordship, the council for the petitioner had mentioned that right to education is a fundamental right with regards to the professional or higher education is concerned, my lordship. My lordship, the right to education is confined to the age of 14 with respect to fundamental rights, my lordship, and it's not a fundamental right when it comes to higher or professional education, my lordship. My lordship, the council also stated that the fundamental right to profession to non-citizens, my lordships. My lordship, it is pertinent to mention that even before this particular amendment, indeed, my lordships.
So for a dignified living here, 14 years of education is sufficient.
My lordship, that particular legislation has to be brought out by the centre, my lordship, but that legislation is not in question before this honourable court in the instant case.
21 is always, it is given wider ambit by the court.
Indeed, my lordship, even assuming the right to higher education will act as a right, my lordship, it will at best act as a directive principle of state policy, which is not enforceable by the honourable court of law, my lordships. If your lordships are convinced, the council would like to proceed to the next. My lordship, the council stated that there is a fundamental right to practice any profession to a non-citizen, my lordship, according to section 24. My lordship, it is pertinent to mention that according to section 24, only a citizen has the right to practice even before this particular amendment, my lordships. there was only a discretionary power that was given to the honorable courts to allow a non-citizen under section 47 as an act of reciprocity, my lordship. And it was not a fundamental right or not any right that was given to a non-citizen with regards to practicing law in the court of law in India, my lordships. Indeed, my lordship, but with regards to the moot court proposition, this was released about even considering the same, my lordship. There is some amount of restriction or discretion that is need to be acted by the honorable court with regards to allowing the foreign individuals to come and practice law in India, my lordships. Indeed not, my lordship. Even in the light of the new advancement, there is some amount of discretion that is granted to the honorable courts in order to facilitate the practice of law by foreign individuals, my lordship. It's not a direct right that is given to a non...
So you have given discretion to the courts.
Indeed, the discretion was there with the courts even before this particular rule that came into being, my lordship. It is given under section 47 of the Advocates Act, my lordships. Much obliged. My lordship, the next objection is with regards to there was no consent that was taken by the state before passing on any of this rule, my lordship. My lordship, it is pertinent to mention that in the instant case, the Moot proposition act as a bona fide document, and for the reason that no other state bar council has placed any objection with regards to the minimum age of admission nor the ASB exam, it can be considered as an implied consent that was given by the State Bar Council with regards to the other state. My lordship, only 3 State Bar Council is before us, my lordship. There are several other State Bar Council that is consented. So it cannot be taken that no consent was taken by the State Bar Council. Consent was indeed taken and it was an implied consent.
So,
Inside, my lord.
Is it your argument that everyone need to be there only then they feel like agreeing?
My lordship, in any case, my lordship, when there is a dispute between the centre and the state, few states will definitely oppose to the views of the centre, my lordship. That doesn't mean that centre does not have the right to pass down any rules just because it's affecting the sentiments of 1 or 2 states.
Why not be taken in this sense? So only in this stage they are sensitive of protecting the rights of the advocates.
My lordship, using the rule of majority, my lordship, taking the implied consent of the other State Bar Council, it cannot be construed that no consent was taken. My lordship, the council is just contending against the point that is given by the council for the petitioner, my lordship. The council for the petitioner stated that no consent was taken. The council is merely trying to say that consent was taken. Indeed not, my lordship. Since the fact doesn't speak about it, the council is leaving the interpretation to the honorable court that there was an implied consent by the other. My lordship, the counsel for the petitioner wanted the honorable bench to presume that there was no documents regarding fake lawyers. If that presumption is valid, the counsel humbly pleads this presumption to be valid.
Assuming your argument is valid on this point, what about the university's concern?
Well, my lordship, that is also with regards to whether the university are agreed by the same, my lordship.
Did you attempt or did you take any measure to check the concern factor of the universities who are imparting the...
My lordship, since the facts of the case are subsilent on an issue...
Not fact, you are the party before us.
Indeed, my lordship, but the party that needed to have filed the case would have been a university, my lordship, in the incident case.
Exactly.
And the State Bar Council or the other association cannot file a case on behalf of a university whose right has not clearly been
But the
imposed.
unfortunate thing is that universities are in your hands now. You are the one who is doing everything. Checking the infrastructure, curriculum, attendance, isn't it? Subjects, everything has been modeled by you.
Which is within the power of...
How dare that be to hesitate against the norms which are formed by you?
My lordship, we are still open to the jurisdiction of the Honorable Supreme Court, my lordship. If any university is aggrieved by the powers that is enforced by the Bar Council of India, they have the right to approach...
The very basic question is that, if at all you have enforced your role in streamlining the legal education for over a period of 63 years after the passing of the Act, actually this anomaly would not have resulted.
Indeed, my lordships. My lordship, the council would like to state that the universities, though they have a say in all these matters, my lordship, since the facts of the case are subsilent, the council pleads not to venture into that particular argument because another issue will be brought into being, my lordship. Much obliged, my lordships. My lordship, the council also stated that the right of livelihood of the individual is affected, taking reference to Rule 10A, my lordships. My lordship, it is pertinent to note that the council for the petition has misrepresented the particular provisions, my lordship. The council stated that any law graduate within 3 years has to enroll, my lordship. My lordship, there is the particular provision merely states that any law graduate within 3 years has to take up the examination. It's not with respect to whether they enroll immediately after or immediately or 5 years after taking the examination, my lordship. It is just with respect to taking up the examination, not with respect to enrollment, my lordship. The enrollment is directly in the discretion of the individual as to when he wants to enroll. My lordship, if the individual wants to enroll it the next year, he has to write the exam now and enroll it next year. If he wants to enroll after 5 years, he still has to write the exam within the 3 years, and he has the eligibility to enroll after 5 years also, my lordship. My lordship, the interpretation that was given by the counsel for the petitioner, indeed, my lordships.
You are saying at any point of time I can get enrolled.
Enrollment, my lordship, but the provisions particularly talks about
Completion of the course.
has to write the examination, my lordship. It is just with respect to writing the ASB examination, my lordship. It's not with respect to enrollment of that individual.
See, you say that only after writing the exam they have to get themselves enrolled.
Indeed, my lordship.
But now the system is you can get enrolled on completion of a law graduation, thereafter take up the qualifying exam so that you will be issued a certificate of practice and move on. So that will be the right check for the persons who are not coming to the profession. Otherwise it will lead to a chaos, you know.
Indeed, my lordship.
Then there is no purpose of law graduation at all.
My lordship, the council would like to state that to bring in the uniformity in the legal profession, my lordship, the curriculum.
Already it is sufficient, they have a qualifying law degree. So that is sufficient for them to enroll in the state bar council. The persons who want to continue to practice, they can choose to write the exam. The persons who don't want to continue in profession, they can always avoid writing exam.
Indeed not, my lordship. The
But
standard.
it cannot be a precondition for an enrollment.
My lordship, the council would like to humbly differ, my lordship. My lordship, the standard and qualification of examination of a law graduate differs from state to state, my lordship. The ASB examination was solely brought in to bring in uniformity with regards to different states entering into the field of legal.
My question is, it is sufficient on completion of a law degree, a student can get himself enrolled as an advocate. But to complete he can also undergo the ASB exam to have a certificate of practice so that he can appear before the courts.
Indeed, my lordships. My lordship, the council is an individual who does not want to practice law need not take the ASB examination, my lordship. Still, he will be considered as a law graduate, my lordship. That individual is free to explore other fields of.
Mr. Counsel, do you have any provision of non-practicing advocate as a provision?
Indeed, not, my lordship. But the
Because
law
the
graduate.
person who has completed law graduate is considered as a law graduate, right?
Indeed, my lordship.
Do we have any provision of non-practicing advocate then?
Indeed.
Because here you are talking about advocate who's going to have certificate of practice, who's going to get enrolled. But there are also class of lawyers who complete law but do not enroll in the bar or do not practice. They do not practice, technically they don't practice.
Indeed.
Because mere writing the examination, ASB examination, and if I have a certificate of practice, that itself is presumed that I am a practicing advocate.
Indeed not, my lordship. It is presumed that you are an advocate, my lordship. Does not specify whether you are a practicing advocate or a not practicing.
Certificate of practice, right?
My lordship, the certificate of practice is given pursuant to the writing of the examination, my lordship. Even with the certificate or without the
Even
certificate.
If I am not getting enrolled in the bar, you are giving me certificate of practice. But even if I am not enrolling in the bar, how will I be treated as an practicing advocate?
My lordship, the certificate of practice is given only after enrollment as an advocate, my
No, the
lordship.
line that doesn't say that State Bar Council shall enroll only a law graduate bearing certificate of practice as prescribed above. That is what it says. Page number 5.
Indeed, my lordship, the council would like to state that this particular issue with regards to the enrollment, the uniform standard of enrollment will be dealt by my co-counsel in detail. The co-counsel will deal this particular issue in detail, my lordship. My lordship, moving on to my submission with regards to the admissibility of the instance. Indeed, my lordship, it is pertinent to mention that pursuant to the amendment that was brought out, my lordship, section 7EA was inserted, my lordship. Section 7EA states to regulate the ASB and lay standards of its regulation, my lordship. My lordship, it is pertinent to mention that the counsel for the petitioner has never contended against this particular section, my lordship, and for the same reason, it is the BCS has the power to lay down the standards. according to the standards, according to the powers that is given to the BCS, such standards have been enacted, my lordship, which is not against the provision of the Parent Act nor the Constitution, my lordships. Much obliged. My lordship, with regards to the first issue, that is the admissibility of the instant suit, my lordship, the council, my lordship, under Article 32, there is a fundamental right violation, it's a sine qua non, my lordship. The council has failed to satisfy the Honorable Court with regards to violation of fundamental right when it comes to Article 21 of the Constitution and Article 19 of the Constitution. Furthermore, the council also failed to establish before this Honorable Court that the petitioner in the instant case has the locus standi to be before this Honorable Court, appearing on behalf of an individual whose right has not been violated, my lordship. Indeed not, my lordship. A public interest litigation can be filed under Article 32, my lordship. But in the instant case, the petitioner has not satisfied this Honorable Court with regards to whether. My lordship, with respect to that, my lordship, an association can file a case on behalf of its members only when the members are in a deprived position, my lordship. This is a case of the Honorable Madras High Court. The council pleads ignorance with respect to the.
You mean to say that only the students who are studying law has to form an association, only they can come and process?
Indeed not, my lordships. My lordship, in the instant case, the first contention that the council will be placing is that there is no violation of fundamental right. Secondly, stating that a group of individuals who has no say in this particular issue, my lordship, because my lordship, they are individual who is already admitted as an advocate. They are not individual who is yet to compete for the ASB exam, nor individuals who are yet to join the law course, my lordship. They have no interest in this particular. My lordship, it was never claimed by the council for the petitioner. Indeed not, my lordship. The council begs to differ. The council just stated that it's Article 32 and a writ of mandamus, my lordship. They never stated it's a public lit. My lordship, even if it is for the public interest. Indeed not, my lordship. With respect to public interest litigation, there is guidelines that has been issued by the Honorable Supreme Court, my lordship, which I would like to submit to the Honorable Bench. My lordship.
No, what is your answer for it?
Indeed.
The petitioner is a juristic person or not?
My lordship, if the petitioner is an unregistered association, the petitioner is not a juristic person, my lordship. They cannot maintain a writ under Article 32 before this Honorable Court. Which was never brought out by the council for the petitioner, my lordship.
Council, are you aware of?
The council pleads ignorance with respect to whether an unregistered association can bring a case before this Honorable Court. Much obliged, my lordship. My lordship, indeed. Much obliged. My lordship, referring to. Indeed, my lordship, that will be dealt by the council with regards to the second issue, my lordship. If your council permits, the council will like to. Indeed, my lordships. Indeed, my lordships. Indeed. Indeed, my lordship. My lordship, the council is not in possession of an Advocates Act, my lordship. Much obliged.
Had the power to conduct the exams earlier.
Indeed, my lordships.
What is the fate of that provision?
My lordship, all issues with respect to the enrollment of an individual or the writing of the ASB exam would be dealt by my co-counsel in detail, my lordship. The council will be able to substantiate in detail as to why the State Bar Council was denied this particular right, my lordships. Much obliged. My lordship, moving on to the second issue, that is with respect to the uniform standard of legal education, my lordship, the council would like to state that it's not violative of Article 14, my lordship. Citing the case of State of Kerala versus PCUL, my lordship, in which it is given that if there is no affection of a vested right, the question of applicability of Article 14 will not arise, my lordship. My lordship, vested right according to various dictionary, including the Cornell Law School Dictionary, my lordship, means an unrestricted and unconditional right that is given to an individual, my lordship. In this case, the right to practice as an advocate and even right to enter a law college and practice as an advocate is not an absolute unconditional right that is given to an individual, and therefore it cannot be considered as a vested right, and Article 14 will not be violated in this case.
The restriction imposed by you is ultra virus.
Lordship?
That is, after having a law graduation, advocates are permitted to enroll. But now you want to expand that by issuing a certificate of practice which they are not eligible because they have not even practiced. See, at least after enrollment, have they gone for practice, then you can impose a restriction that within a period of 5 years, they should qualify themselves to get the certificate of practice.
My lordship,
immediately on completing their graduation, how can you expect them to have a certificate of practice?
My lordship, Council 1 is dealing with the issues pertinent to the admission of an individual into law school. The Council 1 is dealing with the issue with regards to admission of an individual into law school. The Council 2 will highlight that in detail, my lordships. My lordship, it is pertinent to note that in various occasions, such as Veterinary Council of India and the University Grant Commission has granted such powers to the authorities to cap the restriction with regards to age, my lordship, and such power is not an unrestricted...
For all other causes, there can be a cap. But ignorance of law is not an excuse.
Indeed.
Anyone can pursue law at any age, right? Because you say every citizen in this country should be aware of the law. Am I right?
Indeed, my
So
lordship.
then why do you want to bring in a cap for legal education?
My lordship, the awareness of law can be created even outside the purview of legal education that is given by university that is accredited by the Bar Council of India, my lordship. The main purpose of Bar Council and the main function of Bar Council is to regulate the standard of advocates, my lordship. The knowledge and awareness of legal education can be brought out to an individual even outside the purview of what is given by the BCS, and therefore for the same reason, this particular argument will not stand valid, my lordship.
See, this is one thing. Second thing, you are allowing even a person who is a layman to appear before the court as a party in person.
Indeed,
Am I right? So then what's wrong if I study law and if I appear before the court?
My lordship, even in that case, it's the discretion of the Honorable Court to allow an individual to be a party in person, my lordship. The council is not denying the fact that an individual who studied law, who is not an advocate to practice law.
Have restriction for any other courses. Why do you want to have a restriction for a legal course? And moreover, you are saying university can give you legal education. Through what means it can give? If at all BCS is denying it, then what will the university alone can do? And moreover, if that is the case, you have also brought in restrictions with regards to post-graduation courses and research courses. You have made restrictions where you are saying UGC or MHRD should not intervene. That is what your restriction speaks about.
Indeed.
So you have now restricted universities also to offer law courses. Then how do you say now the university will offer law courses, basic law courses? How it is possible?
My lordship, the council is not stating that university should offer basic law courses, my lordship. An individual who wants to pursue law...
Then where will I understand how should I learn law?
My lordship, in the current age of matters, even to be frank, my lordship, my councils are not learning any law from our universities, my lordship. We are learning from other sources. Taking that into account, my lordship, with using leveraging technology.
So council, very good. We have come up with a very good point. If that is the case, then why do BCS did not regulate the legal education and the way in which the courses has to be offered, but you are restricting on the age cap?
My lordship, with regards to bringing up quality into legal education, that is why the Bar Council exam has been made, my lordship, which will be answered in detail by my co-counsel.
May we take it this sense, admitting your own fault?
Indeed not, my lordship. Indeed not, my lordship. If your lordships are satisfied with the issue that is placed by the council too would like to proceed with the next set of issue, that is with regards to third uniform standard of enrollment in bar, my lordship. Much obliged. It is indeed an honor arguing before this.
If it may please the Honourable Court, this is Counsel 2 appearing on behalf of the respondents pertinent to issue number 3, my lords, which pertain to whether the amendment and rules pertaining to the uniform standards of enrolment in the bar violate or exceed constitutional limits and principles, my lord. My lords, before getting into the arguments, the Council would like to divide this argument into 3 limbs, my lords. The first limb that will be dealt by the Council right now is with respect to violation of fundamental rights, my lords, under Articles 14 and 19, my lords. My lords, it is humbly submitted that a well-settled principle of law is to assume that a rule is presumed to be constitutionally valid, my lords. All persons are not equal in all circumstances, and a form of mechanical equality will result in injustice, my lords. Controlled discretion exercisable according to a policy for a purpose clearly enunciated by a statute is not discriminatory, neither it is an unrestricted discretion, my lords. It is humbly submitted that while considering the vias of any subordinate legislation, that is the BCS rules in this instant case, my lords, the court ought to start with the presumption that it is intra-vias, and if it is open to two constructions which would render it valid and invalid, my lords, the courts must opt the presumption that it is valid, my lords. This was enunciated in the case of St. John's Teachers Training Institute versus the regional director, which is enclosed in page number 15 of the compendium, my lords. The council may be so bold as to beg to request the bench to refer to the compendium, my lords. Lords, it is also humbly submitted by the council that the power to frame rules has to be given a wider scope rather than a restrictive approach so as to render the legislative object achievable, my lords. And in this instant case, the Bar Council of India has to have given wide powers so as to render the legislative object achievable, since it is an enabling provision, my lords. It is further submitted that under Article 19 of the Constitution of India, pardon, my lords, under Article 14 of the Constitution of India, as per the case of Ramkrishna Dalmia versus Mr. Justice S.R. Tendolkar, there are two tests of there is a test of reasonable classification, my lords, where the first test of intelligible differentia and the second test of rational nexus has to be established, my lords. And in this instant case, it is not violative of Article 14, my lords, in the sense that the intelligible differentia in this case pertains to law graduates who have qualified the ASB examination and those who have not qualified the ASB examination, and the rational nexus that is sought to be achieved via this is, my lords, referring to the fact sheet, my lords, according to the World Justice Index report, which ranks countries on the standard of administration of justice and human rights, it ranks India as 79 out of 139 countries, my lords. It is humbly submitted that given the sad state of affairs with respect to the legal profession in this country, my lords, the council is not aware with respect to the indices that were taken, my lords. The council submits that it is relied on the World Justice Index report. My lords, it is submitted that the Justice Index report encompasses all the aspects related to law or to regulate the legal profession and is interested in determining the standards of legal education in a particular country, my lords.
The idea of formulating the rules is that to improve the standard of legal education.
Indeed.
Isn't it? What you have been doing for around 64 years.
My lords, it is submitted that since it's been 64 years since there are no reforms.
Are you waiting for the central government to point at your labs?
No, my lords. No, my lords. That is why the council is seeking to, the respondent in this case is seeking to bring out reforms in support of the legal education and promoting legal reforms, which will improve the standards of enrollment and legal profession education in this country, my lords.
You are not interested in bringing the reform. Now, will you please know the fate of section 28B of the Advocates Act?
Just a second, my lords. The council will refer to that.
The sad history of this provision. So let me tell you.
Indeed.
So prior to 1973,
yes,
State Bar Council has been endowed with the power to conduct the
enrollment examination. Yes.
So with you, I think wherein the class 3 of the same provision reads, no rules made under this chapter shall have effect unless they have been approved by the Bar Council of India.
Indeed, my lords.
Are you aware of these developments?
The council is aware of the developments, my lords. For the same, my lords, the council would like to submit the case of O.N. Mohindru versus Bar Council of Delhi, my lords, under which the Honorable Supreme Court.
The fact we want to elicit is that.
Yes, my lords.
Yes, I think a subordinate body to you has the power to conduct the examination.
Yes, my lords.
This is mainly for the purpose of improving the legal education.
Yes, my lords.
Isn't it? Practice also.
Yes, my lords.
Isn't it?
Yes.
You are aware of the fact they have been conducting, the same have been nullified by virtue of deleting the class itself.
Yes, my lords.
Okay?
Yes, my lords.
So after, it has been deleted way back in 1973. You have not taken any effort to just redeem it again.
Yes, my lords.
You have come to 2010.
Yes, my lords.
To incorporate this class and
yes,
then go for invoking the power which is given to you under the miscellaneous head.
Yes, my lords.
No, the very basic question which I want to ask is that when you are not able to regulate or rather bringing reform in the very Advocate Act itself,
yes,
which has nearly some 7 clauses which gives power for forming the rules. How that you are going to reform the legal education?
My lords, the council would like to yes, my lords.
Advocate Acts gives power not only to you,
Yes, my
state body, high court, supreme court, central government, isn't it?
Yes,
Almost everyone is given the power to formulate the rules.
Yes, my lords.
Isn't it?
Yes,
You are invoking a power when the power which is exercised by the state board now has been nullified.
Yes, my
How
lords.
fair is it?
My lords, the council would like to contend that to answer all of these questions, my lords, it would be pertinent to refer to the case of O.N. Mohindru versus State Bar Council of Delhi, my lords, in which it was held that the Advocates Act in pith and substance fall under entry 77 and 78 of list 1, my lords. Also noted of the object of the act, which was to constitute one common bar, my lords.
The basic question is that
Yes,
are you in endorsement of the actions which are taken by your subordinate body?
Indeed, my lords, since it is a delegated legislation, the Bar Council of India is still a work in progress, and the Bar Council of India is trying to introduce as many reforms as possible to reform the legal education and enrollment standards in the country.
The reform has been brought already
Yes, my lords.
and then withdrawn
Yes,
with your knowledge,
Yes, ma'am.
and then you have been waiting for long and then coming back invoking your own power. What's the logical reasoning in it?
My lords, considering the diversity in the country, giving such power to the state bar councils would result in plurality of all the legislations and sub rules that will be formed, my lords. So as to establish uniformity in this particular regard.
Did you go for any empirical study for analyzing by virtue of your introduction of the exam? The quality of legal education will be improved?
My lords, the council has taken the liberty to assume that initially in the 1973 amendment laws, it was the power of the state bar councils were repealed due to the fact that they were not working as prescribed or as assumed, my
What's
lords.
the guarantee that it will be working here and after?
My lords, it is submitted that there has to be some uniformity in ensuring the standards in profession, my lords.
There are certain riders
Yes, ma'am.
where you are bringing in certain norms which are touching upon legal education.
Yes, ma'am.
You need to consult the universities.
Yes, ma'am.
You need to consult the state bar,
Yes, ma'am.
which you have not done it in abstract sense.
Yes,
And you are trying to invoke your own power of framing the rules.
My lords, these powers.
Interestingly,
Yes,
you are
ma'am.
endowed with so many functions.
Yes, my lord.
Obviously, many of the functions are put to death knell.
Indeed, my lords.
You are not discharged all those functions. But you are very serious enough to just inculcate some changes in the legal education, isn't it? So at a later point of time.
My lords, the powers given to the Bar Council of India are in consonance with the Advocates Act 1961 under section 49, my lords. The section 49, although is not exhaustive, my lords, has given a broad scope for interpreting the provisions, my lords, for the betterment of the provision, my lords. In this instant case, my lords, the council would like to refer to section 49, which gives the broad powers or general powers of the Bar Council of India to make rules, my lords. That's the contention of the respondents, that although the powers may not be exhaustive, my lords, in the object of furtherance of education.
You are not denying the fact you had the power.
Yes, my lords.
But the only question I want to elicit from you is that
Yes, my lord.
the power when exercised by the state bar and withdrawn later,
Yes, ma'am.
isn't it, has been resumed by virtue of our own powers.
Yes, my lord.
Now, what is the urgency? No, why you are delayed so much? What's the urgency of bringing it now? What's the bona fides in your action now?
My lords, since there are several issues plaguing the legal industry, my lords, the Bar Council of India at this juncture found it pertinent to introduce reforms at least now, even if not for all this period, my lords. Indeed, my lords. My lords, it is submitted that as per section 7, clause 1, clause G of the Advocates Act 1961, a key function of the Bar Council of India is to exercise general supervision and control over the state bar councils, my lords. The state bar council is being tasked with the function of enrolling persons as advocates, would mean that inserting names in an orderly manner into the register or the roll maintained by such state bar council, my lords, and any condition to be specified by the state bar council would be a thing which needs to be positively fulfilled in order for the state bar council to proceed and to admit the person on the rolls, my lords. The council is not aware of the numbers, my lords.
As the body is regulating the bar,
Yes, please.
how many people are really not serious in observing the practice?
My lords, it is in reasonable, it is an interest, it is in the best interest of the public that the law is assumed to be working for the welfare of the people, my lords.
Indirectly,
Yes, my
you have
lords.
permitted advocates who are not serious enough to pursue the practice,
Yes, my lord.
to take the risk of cases.
My lords, that is not the case, my lords. The object behind this legislation was to enhance the legal profession, my lords, and for the same, the ASB examination is conducted, and it was a reasonable...
So how does ASB examination will improve the quality of legal profession?
Yes, my lord. With respect to that, the ASB examination tests the law graduates on the subjects that were studied, my lords.
Which they have passed in the college.
They have passed, my lords, but as a rule of, my lords, it is contended that...
Have you prepared the curriculum syllabus for ASB examination?
My lords, it is the subjects that were already studied in the law graduate program, my lords.
That itself my knowledge is tested. Then again, why do you want to test? You are putting the students in harassment, right?
My lords, as contended by my co-counsel, it is submitted that most of us do not...
Said also he did not study in the university.
My lords, that is the contention, my lords. So for the same, at least at the time of enrollment in the bar exam, my lords...
The open book examination, I will be doing it.
My lords, although it is an open book examination, my lords, the onus is still upon the...
When you say that you are improving quality of legal profession,
Yes,
that should be some kind of a logic behind in introducing any examination. What is the logic behind this introduction of this examination?
My lords, the subjects are broadly, the subjects which were...
You say that State Bar Council will not regulate it and you will be regulating everything.
My lords, that is under the powers given to the Bar Council of India under Section 14.
You have taken the powers. You did not say that. You don't say that.
My lords,
that is a power given. You have taken arbitrarily. You have reacted, and you have forget the word federalism completely.
My lords, the powers are given via legislation, that is the Advocates Act 1961. My lords, so the powers have
and
a broad.
You by yourself said that is in the entry list 1, right? So
yes,
you by yourself has done everything.
My lords, the council would also like to mention the Article 246 of the Constitution of India, my lords, which pertain to the relation between union and states, my lords. In that case, the council would like to read the article verbatim, my lords. Although the state legislatures have the power to make the laws with respect to any of the matters enunciated in the concurrent list, my lords, a careful reading of clause 2 of Article 246, the powers of state legislatures is subject to clause 1 of article, my lords. Subject to, in this case, my lords.
When I am saying the same thing, council, you are forgetting the word federalism. You have forget cooperative federalism, you forget federalism, everything. Now you have taken every power in your hands.
My lords,
and you forget the role of State Bar Council also. And you want to curtail them from doing anything. That is the thing.
My lords, that is not the case, my lords. As has been contested by the council in the previous case of O.N. Mohindro, my lords, the legislative intent of the Advocates Act was to constitute one common bar and one common machinery, my lords. And in a country like this, where several advocates are there, the supreme power has to be given to a body like the BCS, my lords. Sure, indeed, my lords. With the permission of the bench, my lords, the council would like to move to the prayer. In light of the issues raised, arguments advanced and the authorities cited, it is humbly prayed that this honourable court be pleased to hold, adjudge and declare that the writ petition is not admissible before the honourable court, and even if the case is maintainable before the honourable court, it is humbly prayed that the amendment and rule pertaining to the uniform standards of legal education by the BCS are not arbitrary to constitutional principles and guaranteed rights of citizens and non-citizens, and the amendment and rules pertaining to uniform standards of enrollment in the bar does not violate or exceed the constitutional limits or principles, and pass any other order that it deems fit in the interests of justice, equity and good conscience, and for this the respondent as in duty bound shall humbly pray. It was an honour arguing before the bench, my lords.
The council appreciates the efforts of the learned counsel for the respondents for substantiating the case, but your lordship, the counsel for the petitioners set forth, but your lordships, the counsel for the petitioners contends that the contentions made by the counsel for the respondents are misleading the honorable court as the contentions are merely self-interpreted, self-assumptions, and these misinterpretation cannot be considered as a prima facie evidence for proving the non-violation of the fundamental rights, your lordships. Secondly, your lordships, the amendment which is made under the Rule 5A, subclause A of the Part 4 restricts the legal education by imposing the upper age limit. Your lordship, the counsel for the petitioners questions the arbitrary nature of the amendment as it is discriminatory on the basis of the age. Your lordship, the council, as the learned counsel of the respondents agrees that the advocates can be permitted for the enrollment at any time. The council is grateful for the contentions. Further, your lordships, The counsel for the petitioners questions the bona fide intention for the purpose of the ASB examination, as there is the existence of the law course itself. Further, Your Lordship, the counsel, with reference to the section 7 clause H of the Advocates Act, which states that the amendment shall be consulted for the universities. But the learned counsel of the respondents did not consult, hence the state bar councils of Tainadu, Malanadu and Tulunadu is before the constitutional bench. Your Lordship, the counsel for the petitioners believes that the Supreme Court is the guardian of the constitution, and the bench would favor the petitioners, as the bench have to emphasize on the aggrieved party, as there is a glare violation by the counsel for the respondents. Here the counsel rests the rebuttals. It was an honor to plead before Your Lordships.
My Lordship, the counsel would like to restrict the rebuttal to the rebuttal that was proposed by the counsel for the petitioner. For the sake, the counsel would solely like to rely on two cases, my Lordship. The first one is with respect to the Supreme Court case of Inamdar Wahab versus Symbiosis Society Law College, which I would like to read verbatim, my Lordships. My Lordship, it states, no profession can maintain a high standard if it is allowed to be inundated by persons who reluctantly took up the law course because having failed to secure admission to courses of their choice, they have nothing else to do. The prescribed minimum qualification therefore has a rational nexus to the purpose sought to be achieved. We also do not feel that the percentage fixed is a manner arbitrary. It is reasonable, and more so in view of general pattern of percentage of marks generally obtained at qualifying examination. Indeed, my Lordship, the judgment relates to the percentage of marks that is secured by the individual, my Lordship. This particular portion of the judgment relates to the percentage of marks. My Lordship, regardless of whether the judgment of the Honorable Court is overruled, my Lordship, the counsel would like to place this as an arbiter. The counsel pleads ignorance with regards to. My Lordship? My Lordship, the counsel would like to place this as an arbiter before this Honorable Court for the sole reason that the reason that was stated by the Honorable Court, my Lordship. Finally, my Lordship, the counsel would also like to cite the case of Parameshwar Prasad as the Union of India, in which the Honorable Court said it is not the petitioner's case that the restriction imposed have no relation to the fitness of the person required to carry on the profession of law within the scheme of Act, my Lordship. Basing my arguments on these two propositions, I would like to rebut the rebuttal that was given by the counsels, and with this, the counsel rests, my Lordships. Much obliged.
Kind attention please, all the participants and volunteers are requested to proceed for lunch. Let the participant proceed first, finish off your lunch and get back here within half an hour. Yes. Volunteers, kindly stay back for 2 minutes. Yes. Participants, I request everyone to kindly proceed for lunch.
Sure, sir. All right.